You're listening to In the Balance, an Iowa Judicial Branch podcast. Thank you for joining us for another episode, our first of 2021. Today, we are going to take a longer look at one of Iowa's appellate courts, the Iowa Court of Appeals. We are joined by the current Court of Appeals Chief Judge Thomas Bauer, who will take us through the establishment of this court and the role it plays in Iowa's judicial branch. Today we are talking about the establishment of the Iowa Court of Appeals and are joined by Chief Judge Thomas Bauer of the Court of Appeals. Before we get started, Chief Bauer, can you tell us a little bit about your path to the Court of Appeals?
Sure. I went to college in Central Illinois, developed a real interest in criminology and economics, political science, went to law school at Drake, graduated in 1987. And then started as a prosecutor in Blackhawk County, based in Waterloo. And after 4 or 5 years, I had some judges ask me if I'd ever thought about being a judge. And there happened to be an associate position available, district associate judge, which is appointed by the district court judges. And fortunately, I was appointed as a district associate judge. After a couple of years, I moved to the district court. After a number of years from that, I became the chief judge of our district, the first district. And then about 7 years ago, in 2013, I went on the Iowa Court of Appeals, and about 14 months ago, which would have been October 2019, I was elected by my colleagues to be the chief judge of the Court of Appeals.
And apart from your duties on the bench, what are some of those responsibilities that you take on as chief judge?
Well, in addition to presiding at all the cases that I'm a member of, there are some administrative things. I have the greatest colleagues, greatest people I've ever worked with in my entire life. So there's not a whole lot of things, but there are things every month. Every couple of weeks we have a court conference. And the interesting thing about that is the different perspectives when we're dealing with court issues. My background could be described as fairly typical, but we have a number of judges on the Court of Appeals who were in private practice before they went on the bench. Some who had been trial judges, some who had worked for agencies, state agencies. So when we have our meetings, everybody brings a different perspective with them. Cases are screened by the Supreme Court and assigned to us, and then between my staff attorney and myself, we determine which cases are to be set for oral argument. And those kind of come in regularly, but we never know exactly how many cases we're going to get. Any given year, we'll have between 150 and 160 oral arguments. The rest of our cases, which would be about 1,000 cases, otherwise would be non-oral arguments. So I make a determination based upon what the parties have requested, whether they want oral arguments, whether it's a unique issue, whether it's something that may help the Bar Association, the attorneys, as they're doing their work. And if it's an interesting issue that maybe hasn't been discussed before or hasn't been discussed in some time. Of course, being the chief, you have personnel issues, but we have great camaraderie. Sometimes we're called the court of collegiality because we do get along so well. And I don't know if it's the people that come to the court that get along so well or whether it's the court itself that makes the people get along just because of the sheer volume. The court conference, as I mentioned, is every couple of weeks. And then there are special projects, for example, because of COVID. we decided to go to virtual arguments. Those started last May, and we were kind of a guinea pig, I guess, for lack of a better term, for the appellate court. And then early in the fall, 3 of our judges, Judge Tabor, Judge Greer, and Judge Schumacher, formed a committee and did a survey of all the attorneys who had appeared virtually, just to see what they liked, what they disliked, whether they thought it might have a role in the future. And so we've shared those results with Chief Justice Christensen. And so there are things that happen like that as well. So it's kind of always a moving target.
Right, I can imagine. So we've talked in the past on this podcast about our appellate court system and how it differs from the trial courts. But the Court of Appeals is much younger than the Supreme Court. And I was hoping you could talk a little bit about how it was established and the role it now plays in our judicial system.
Sure. The Iowa Supreme Court is a constitutional court set up by the Iowa Constitution, and the Iowa Court of Appeals is what I would call a statutory court. It was created by the legislature. And there's a great law review article written in about 2011 by Judge Doyle and Judge Sackett that really gives the history. It's a Drake Law Review article and kind of the back behind the scenes type of things. But there was a need, because of how busy the Supreme Court was, to think about either having kind of commissioners, like assistant justices that would write opinions, and then the Supreme Court would review those, or actually to have the Iowa Court of Appeals. So in 1976, the Iowa Court of Appeals was created. We still have in our office the editorial, the pro and con framed, where both sides put their opinions in the Des Moines Register. And it's interesting to see the arguments that the attorneys had back then. So in 1976, we came into creation because of the legislature. There were 5 judges at that time. 1983, the numbers were still continuing to trend up. Everybody was additionally busy, so they added 1 more judge to make 6, and decided that all of our cases would be heard in panels of 3. So at any given time, there are 3 judges that preside, whether over an oral argument or participate in the non-oral argument. Then in 1999, again to deal with the continuing trend of cases, the court went from 6 judges to 9 judges, and we still work in 3-judge panels. And what that allows us to do is it allows us to do what our court is told to do, which is justly dispose of a high volume of cases. And our court also is simply to correct error. We're not to necessarily change the law. And so we're able to work at a much higher pace than other courts. And with the 3-judge panel, we basically divide the cases into 3, although we do have senior judges that participate primarily in non-oral arguments. And without them, we would be even busier.
So you mentioned that the court saw some changes in the 1980s and 1990s. What are some of those benefits of those changes? You've talked about the caseload. Would you say that your 9-member court now is dealing adequately with those numbers of cases?
We are addressing things as quickly as we can. We generally have a backlog of cases, but we get our cases out from the time we hear them or they're assigned. Usually our cases are ruled on within 60 days. Some of the other benefits, other than getting through a number of cases, is we rotate with the other members. So every year I'll have the opportunity to work with the other members of the court. And like I said earlier, that brings different perspectives. and brings, I think, a much broader understanding of the law, maybe what the opinion should be, things that I may not have thought of. And we conference those cases, whether it's the oral arguments or the non-oral arguments, with our panel and with the staff attorney and the law clerk. So I think that continual change allows a better exchange of ideas for us. I think another thing that is beneficial is when you work in panels like that, and I guess it's similar, but when you work in panels like that, everybody brings something else to the table. Like I said at the very beginning, we have judges with various backgrounds, and those various backgrounds help a great deal. The way that it's set up is, I think, ideal with our panels, although there are times when we meet in larger panels. We've had panels of 5, we've had panels of 6, and once, since I've been on the court, we have gone en banc, meaning that all the judges participated. And that's usually something we think that is extremely important, that we have all 9 of us weighing in to deal with all those little cracks and crevices of the law, because the law that we're dealing with isn't usually black and white, it's very gray.
Right, absolutely. You mentioned there are exceptions to sitting in those random panels of 3. What would a case look like where you would call for a larger panel, whether it's all en banc or 5 versus 6?
The en banc case was kind of a constitutional issue, and it was assigned to us by the Supreme Court, and they were encouraging of our request to go en banc, and we, of course, had to use the Supreme Court courtroom because we don't have enough chairs in our courtroom for the 9 of us. But there was a constitutional issue, and there was such a varied opinion before the arguments from the various judges. And it wasn't like a big murder case, it wasn't a huge civil thing. It was something which was important to the people that were a part of it, but it wasn't some great big famous case. But it was a case that there were different opinions about, and we thought the best way to deal with that would be to have the attorneys come in, make their arguments, and we would all have the opportunity to ask questions. When we've had smaller panels, it has been if there's a similar issue between 2 cases, or maybe co-defendants, where the co-defendants were split up when the cases were assigned, and so we've done that too, but that's the exception. Anything but 3 is the exception.
Right. And when it comes to writing those opinions and working with your panel, is it common practice to stick to the 3 judges in that panel when writing and approving that decision? Do you seek advice from other judges or approval? How does that process work?
Well, when the cases come in after they've been screened by myself and my staff attorney, the cases are assigned randomly. And that's one of the beauties of the court, is it's all random. So sometimes you might get what you perceive to be an easier case, and sometimes you may get a very complicated case. So you don't really know what's coming in. After the case is assigned, most judges will do a bench memo or a draft opinion, just laying out the thoughts and the issues to share with other members of the panel. It's certainly not binding, but it kind of puts things in perspective, maybe what they think is important. But if I've drafted an opinion, say for a non-oral argument, and I have a question, I will first ask my staff, which would be my staff attorney and my law clerk, and then I may go ask my panel members. For example, I was recently on a panel with Judge Mullins and Judge Doyle, and I had a question, and they had looked at my draft opinion and gave me some feedback. But the nice thing is I can go to any of my colleagues, even if they're not on the panel, and get suggestions from them. You know, there are some judges that have a real passion, if you will, or more knowledgeable than other judges in certain areas, just by their interest or maybe what they did before they came to the Court of Appeals. And so it's not unusual to maybe go bounce some ideas off of them. And the nice thing is everybody's so receptive.
So what are some of the courtroom proceedings that citizens might notice a difference between the Supreme Court and the Court of Appeals?
The biggest difference between the two courts is the time allotted to the attorneys. The Supreme Court gives each side 15 minutes to present their argument, and then the person who's brought the appeal gets an additional 5 minutes for rebuttal to rebut what the first person had said, or their opponent had said. In the Court of Appeals, we have a 10-10-5, so each side gets 10 minutes, and then there's 5 minutes in rebuttal. I think that was primarily done because much of what the Supreme Court does may have broader public impact. It may be more finite, where there needs to be some additional drilling down, if you will, into some of the facts and the law. And since they deal with lots of things that have not been argued before in the Iowa courts, there's additional time. Other than that, the formality is the same. They have a larger courtroom just because of the size of and the number of people that participate. I think they probably have more observers than the Court of Appeals does. Other than that, we're pretty similar.
You had said earlier that the Court of Appeals deals mainly with addressing errors, and I have heard it termed an intermediary appellate court. So what does that mean in terms of the cases that you hear?
Okay. The vast majority of states have an intermediate or intermediary appellate court. Sometimes they're called something different other than the Court of Appeals. And basically, as I had said earlier, our cases are assigned to us. The Supreme Court decides, for the most part, what types of cases we do, although juvenile cases and that, we primarily get all of those. And then what happens is after our ruling comes out, the losing party, has one final remedy, and that's to ask for what's called further review. And the Iowa Supreme Court can grant further review to kind of check whether or not we got it right. So there's a final check and balance. And so we kind of sit in between the trial judges and the Supreme Court.
Lastly, I always like to ask the people I interview that if there's one message you could leave our listeners with today, what would you like it to be?
I know the Supreme Court does too, but we really care. Every time myself or my colleagues look at a case, even if it might be an easy case in our minds or not a difficult issue, we realize that there's people behind the briefs, and that although some may not think that the case is very important, the people that we're writing for, it's the most important case in their lives. And so we try to take that into account. I'd like people to know too that we work extremely hard. We heard over 1,100 cases in 2020, and between the 9 of us and about 7 senior judges, we're extremely busy, but we all knew that going in. So it's not a complaint, it's just an observation. And what I really want people to know is that just like lawyers and citizens, we're humans too. We make mistakes. We try not to. We have the same issues that other people have, whether it's kids or pets or spouses or whatever, and we just happen to be in a decision-making role when someone has a controversy or they can't resolve their case. So we do our best. We work extremely hard. We're very proud of the work that we do, and I would encourage anybody to come watch us in person after the pandemic is over and things are back to normal, or watch us on the YouTube channel. We have a YouTube channel, and our schedule is published a week in advance of our arguments, which happen once a month. And just see what it's really like, because it's a fascinating process.
Thank you so much, Chief Bauer, for coming today.
Thank you.
You've been listening to In the Balance, an Iowa Judicial Branch podcast hosted and produced by me, Marissa Gaal. If you would like more information about Iowa's courts, you can visit www.iowacourts.gov. You can also follow the Iowa Judicial Branch on Twitter and YouTube at Iowa Courts. This episode of In the Balance is now adjourned. Until next time.